Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Yeater, and today's episode is What Can Be Done? Sustainability and Competition Law in Europe. For those of you following along at home, this is a follow-up episode to episode number 64, released on June 8, 2020, called Where Next? Climate Change, Sustainability, and EU Competition Law. Today, we'll be discussing the latest guidance from competition law regulators in the EU and UK on the issue of the application of competition law to sustainability agreements, including those related to climate change issues. And my co-host today is Matthew Hall.
Hello, Aaron. Our guest today is Jay Modrall. Jay is an antitrust and competition lawyer based in Brussels with Norton Rose Fulbright. A U.S. qualified lawyer by background, he's a member of the bar in New York, Washington, and Belgium. He advises on EU and international competition work, in particular international M&A. He also has extensive experience with EU financial regulatory reform and a close interest in sustainability issues and competition law. Hello, Jay.
Thank you, Matthew, and thank you, Aaron. It's good to be here.
Well, thank you very much for joining us today. So we're looking at sustainability issues and competition law in the EU and UK. When we refer to sustainability in this context, what are we covering?
Well, that's already a rather difficult issue, unfortunately. There are various ways to define sustainability, and it depends on which antitrust authority you're looking at. In some cases, authorities refer to UN guidance on sustainability, which is quite broad, including not only environmental, but a wide range of other animal welfare, labor, etc. Objectives. Whereas other authorities limit their activity or their focus on sustainability agreements to the environmental sector. And I'm sure we'll come back to in more detail, which authority is taking which approach.
Okay, so we're not only talking about climate change, we could be talking about a wide range of issues. Just to kick us off here, we're talking largely about agreements between competitors in relation to sustainability, so sustainability agreements. Can you give us one little example so we kind of frame what we are going to be talking about today?
Well, the most fraught cases do indeed involve agreements among competitors, and those could be an agreement not to purchase inputs from suppliers who do not meet certain sustainability standards, or similarly only to sell downstream in channels that, again, satisfy sustainability standards. But I would just caution there because sustainability agreements often involve a supply chain element. And one of the issues, I think, is that sometimes the focus on the horizontal component of sustainability agreements leads to a little bit of confusion there.
That's a good point to remember. As we say, we often refer to it as sustainability agreements, assuming it's always between competitors, but we can have a vertical issue. So why has antitrust, or in the EU and UK parlance, competition law, become a big issue in relation to global and European efforts to promote sustainability?
Well, as everyone knows, I think in recent years, there's been a lot more focus on sustainability issues, and in particular in relation to climate change. And in many sectors, there's a understanding or a consensus that cooperation, again, among competitors often, will be required to meet those objectives. But by the same token, as we all know, cooperation among competitors raises antitrust concerns. And there's been a fear that antitrust, rather than being part of the solution, may be part of the problem by impeding or deterring companies from entering into beneficial sustainability agreements.
Is this something which really only impacts your big companies, your oil and gas multinationals, your huge FMCG manufacturers and their supply chains? Or is this something which, smaller companies should also have a concern about?
Oh, absolutely. It's right across the economy, although obviously the enforcement risk is not the same for all sorts of companies. But just to give you an example, the Dutch Antitrust Authority recently cleared a agreement relating to garden stores. So those are obviously not, your Fortune 100 kind of companies.
Absolutely. That was the pesticide in garden products case, I believe, from the Dutch authority. All right, so let's frame this a bit more for the non-EU and UK listener. There's some key issues here in terms of how the law works. We don't want to get into a lesson on EU and UK competition law, but I think we need to understand in outline how this, what the legal background here is and how the regulators need to look at these types of arrangements.
Well, that's a good point. And I think actually it's relevant to why there's so much activity in this area, specifically in Europe. And I think in broad terms, the EU Treaty on the Functioning of the European Union, but also national laws, starts with a prohibition of, quote unquote, anti-competitive agreements, decisions, or concerted practices, subject to the possibility for exemption if a number of criteria are met. So rather than having a very general rule of reason, as you might have in the United States, you have a statutory, or in the EU case, a constitutional level of criteria which need to be met in each case. And as a result, you have a tradition among European enforcers of developing quite detailed guidelines. And at the moment in Europe, we have 3 leading enforcers, all of which are in the process of finalizing guidelines on the assessment of sustainability agreements, which, as far as I know, is unique in the world.
Absolutely. Yeah.
Oh, Jay, I was just going to ask. I assume that in contrasting that with the United States, there's a fair likelihood that those detailed guidelines are going to run in tension with the interest or lack of interest from U.S. authorities on these issues.
Well, there's a fair amount of tension among the authorities here in Europe, too, which we'll get into. But I think it's fair to say that there's a broad area of agreement on types of cooperation that don't raise any issues and wouldn't raise any issues no matter where. But there's a lot of discussion over a rather narrow but important category of agreements where even within Europe, there's different approaches to the assessment of consumer benefits and what kind of which consumers and which benefits you look at, where I don't think the U.S. enforcers are anywhere near that specific, but you would know better than I am.
As you say, the EU and UK regulators are getting into this in a lot of detail with the guidance that is coming out. What are the two? I think you kind of hinted at this or alluded to this, Jay. They're kind of a couple of camps. If you look at how the regulators are thinking about this, some consider that that regulation is really what should be driving all of this. Others consider that it's important that they give guidance and that competition policy really has a role to play in terms of helping companies. How do you How would you characterize those two camps, or put a bit more meat on those bones for us?
Well, that's a very important point, and one where, honestly, I think there's a bit of a false dichotomy going on. You often hear people who are skeptical about the role of sustainability objectives in any form of competition analysis. They will say, well, sustainability objectives are the proper subject of regulation, not antitrust, or words to that effect. And as I say, I think that is a bit of a misconception, because the point in an assessment of a sustainability agreement is not the antitrust enforcers trying to promote sustainability objectives in the guise of competition. The point is, should they apply competition principles to block the cooperation to achieve sustainability objectives, which may or may not be achievable by regulation? And obviously, in the context of an analysis, those benefits have to be identified, they have to be supported, they have to be quantified. And to my way of thinking, it reflects a confusion about what the antitrust authorities are doing. If they, it's not them saying we think people should cooperate to achieve sustainability objectives. It's competition authorities saying we are going to look at the benefits that are being advanced, and because they are sustainability benefits, we're going to apply a certain filter. We will or we will not take them into account. But if the benefits are there, and if they're quantifiable and they meet a framework, why shouldn't they be taken into account, just like any other benefit?
Jay, that does sound a lot like the rule of reason framework in the United States. It sounds like it adds maybe a different component of the benefits from what one might ordinarily consider in that rule of reason framework. But in that sense, it's a balancing test. Is that right?
Yeah, that is right. I think where things get difficult is when you try to get very specific about which benefits, only ones that are quantifiable, also ones that are not quantifiable, what time frame, only ones that are foreseeable in the near future or over a longer term, and which consumers.
Right.
Do you have to show that the benefits that will be received by consumers apply to the same consumers who may suffer a competitive harm, usually in the form of a price increase?
We'll get on to that issue in a bit, I think, Jay. But just coming back to Aaron's point as well, and your previous comment, it does seem that there is a bit of, if you like, subjective analysis here, even though you say they're just applying standard rules. I mean, for example, the CMA's draft guidance reflects the fact that there is a degree of public concern about climate change. And so they are taking that issue into account, as well as the, quote, magnitude of the risk that climate change represents in their analysis of agreements and other arrangements. So doesn't that suggest that they are promoting their view of what might be beneficial or otherwise?
Well, I wouldn't put it that way. Again, it's for the companies who want to engage in cooperation agreements to determine what's beneficial and what isn't. And of course, in the self-assessment process, they also analyze them from an antitrust perspective. The CMA isn't saying, I don't think, companies should be cooperating in order to mitigate climate change. What they're doing is they're saying, in the case of climate change agreements or agreements to promote climate change objectives, we will apply a more flexible set of criteria to this consumer benefit test that I was talking about. And there, Matthew, you will know more about this than I. They're making a distinction which we don't see either at the EU level or in the draft Dutch guidelines. And they're doing so specifically to address a recent UK court decision involving Sainsbury and MasterCard, where this issue was addressed in a rather conservative way, and I wouldn't be at all surprised if we see court challenges in the UK to try and test whether that distinction is viable.
Absolutely. We've referred several times to the guidance, Jay, and I think it's helpful for everyone to understand what guidance is out there, what kind of timeframes these draft guidances have been running to, and what are the key documents that we should be looking at here when people are considering what regulators are saying in the EU and UK. Can you just take us through where we are in these documents?
Yeah, we're at a really extraordinary point in that area because we have, as I mentioned, three leading enforcers, all of who have draft guidance out on the assessment of sustainability agreements, and all of whom will be presumably finalizing those guidelines in the course of this year. The pioneer in the area is really the Dutch, who published draft guidance already in 2020, and then based on results of consultation, published an updated version in 2021. But those guidelines, oddly enough, you might think, are still in draft form. I understand that the ACM is expecting to finalize them this year. They may well be waiting for the European Commission, which is in the process of updating its guidance on the assessment of horizontal cooperation agreements. And in that process, they have added to the draft new guidelines a chapter on sustainability agreements. And that was published in March of last year and is expected to be finalized in the coming months. The most recent, the new kid on the block, is the CMA, which published draft guidelines in February 2023, and they are now out for consultation and will be finalized based on the results of the consultation. And they take a sort of middle-of-the-road approach between the greater level of flexibility shown by the ACM guidelines and a more restrictive approach, I would say, taken by the European Commission.
We'll get on to, I just want to ask you in a moment about, and you've already alluded to this, but the similarities or a bit more about the similarities or differences. But I think it's quite interesting that the head of the Dutch authority has certainly, I think, been a bit critical of some of the EU draft guidance in a couple of areas, in particular in relation to the treatment of fair share in relation to the exemption analysis. So it is interesting to see, and also I observe that unhelpfully for advisors, not only is there that kind of criticism between a national regulator and the Commission, but also there's a lot of incoherency, I think, in terms of the wording that's used. You have the EU talking about sustainability agreements, you have the Dutch talking about sustainability agreements and environmental damage agreements, you have the UK now talking about climate change agreements, so it's not exactly a consistent position, I think, for advisors and companies. But just looking at these guidelines, I think you've mentioned this a bit already, but just to emphasize it, because this is really the key, I think, really, what is the broad area of agreement here in terms of analysis, and then what are the key differences, really looking at the legal analysis of these arrangements?
Yeah, I think you're right to pause on the areas of agreement, because the areas of agreement are quite broad, and the areas of disagreement, while important, are quite technical. And I wouldn't want to leave anyone with the impression that there's fundamental disagreements among the authorities, because I think it's safe to say that all three authorities and other authorities as well agree that there are all sorts of environmental or sustainability related initiatives that don't raise any competition issues. And there's a wide range without trying to be exhaustive. Those could include any unilateral actions to promote products as a competitive factor that are sustainable or green, or some other adjective that you like. Joint action, including joint action by competitors that takes the form of joint lobbying, what in the US they would refer to as Norr-Pennington activity. Obviously doesn't raise any issues. Also, voluntary initiatives which may involve competitors but don't oblige or don't require any action, such as developing a common terminology for the assessment and comparison of sustainable products or less sustainable products, or developing a common rule book or voluntary code of conduct, which again is voluntary, doesn't oblige anybody to do anything, or developing a set of technical standards, which again are not binding. All of these things typically would not raise any antitrust issues. I think I'm always running a risk of getting a counterexample shown me, but I think under any jurisdiction, those would likely be considered just fine. The problems I think run into two areas. One is the concepts which we have in the EU and also in the US and elsewhere of by object versus by effect assessment, or per se versus rule of reason assessment, where, to use the EU terminology, if a kind of conduct such as a collective boycott is considered to be a by object restraint or per se restraint, then you don't even necessarily get to the benefit versus harm assessment, because the burden of showing that your agreement is qualifies for an exemption is so high. And if you think about the quintessential sustainability agreement, where people in industry agree that they will not purchase from suppliers who are not adhering to sustainable practices, for example, it's very easy to imagine that that kind of agreement is considered a by object restraint. So being able to say, well, hang on a second, this would normally be treated as a by object restraint, but in this context, we know that the object isn't restraint of competition, it's promoting sustainability, and therefore we'll move on to the next phase of the analysis, which is weighing the competitive harms and benefits. And then finally, and then I'll be quiet, to get onto the areas of disagreement in that last phase of weighing harms and benefits. Again, it's which harms, which benefits, which consumers, and what is the quote unquote fair share in the EU treaty terminology.
Well, I think it's important, Jay, to look at that in more detail. You say you'll stop talking, but that is probably the key legal area of difference when certainly if you're looking at the analysis of an exemption. So, as you say, what are the efficiency gains? So what are the objective benefits that we're allowed to measure in weighing in the analysis to weigh against the anti-competitive impacts? And also how you analyze the fair share for consumers. So another part of the requirement when you're making this overall analysis. So I think, as I see it, we have what are the objective benefits? What is the adequate compensation we can consider, or how do we measure that? And also, as you say, what groups should be benefiting? And so could you just dig a little bit more into those three areas for us so we can understand where the areas of disagreement or agreement are with the regulators so far as we can tell, in the absence of a huge amount of case law, particularly on kind of climate change or those types of cases?
Yeah, well, that is indeed the crux of the debate, where the rubber hits the road, so to speak. And it's interesting to compare the approaches taken in the three sets of guidelines, which are currently on the table. I guess to start with the EU's guidelines in the middle, and they're sort of in the middle of the spectrum here. The Commission has historically been very skeptical, at least since 2003, of sustainability objectives in the assessment of horizontal agreements. And only, I understand, under some pressure did they decide to include a chapter on sustainability agreements at all. And when they did so, they've taken sort of baby steps, if I can put it that way. They have acknowledged in the sustainability agreement chapter of their draft guidance that not only price-related benefits, but also sustainability-related benefits can be taken into account. And they create a useful framework for that purpose. They distinguish between what they call individual use benefits, individual non-use benefits, and collective benefits. And I think the biggest conceptual hurdle for them is the broadest category of benefits, because that opens the door to considering benefits which are not related to the use or even the non-use of the specific products which are produced as a result of the agreement, but benefits which are accrued to a broader group of people, including society as a whole. Where the Commission stops short, and we'll come back to the differences in the way the Dutch and the UK have treated this issue. The Commission, so far anyway, says that although the types of benefits can be different than not limited to benefits associated specifically with better quality fruit or what have you, but a broader set of benefits, they say that the consumers who benefit should substantially overlap, quote unquote, with the consumers who may suffer the competitive harm, which will normally be a price increase. Now, that is more restrictive than the Dutch approach. Starting in 2020, they took the view, and continue to take the view, that in its assessment, the authority should be able to take into account benefits, quote unquote, to society, not simply the group of people who are likely to consume the downstream products, so to speak. And society, at least in principle, can include not only consumers who aren't using the product, but also potentially consumers who are halfway around the world, which is an important element if you think about sustainability agreements affecting global supply chains. The consumers who benefit from a reduction in CO2, for example, may be all over the world, but maybe the greatest benefit from a sustainability agreement will accrue to people in the Amazon or wherever. So halfway around the world from Amsterdam.
I'll stop you there for a second, Jay, because isn't there a distinction here between we're talking about sustainability agreements generally in the abstract, but here the Dutch guidance or draft guidance is limiting its analysis there to, quotes, environmental damage agreements. Isn't it in terms of a benefit to people outside the market? So they're not saying, for example, an animal welfare agreement can benefit people outside the market. It has to be an environmental sustainability agreement.
Yeah, no, that's correct.
Or environmental damage agreement, I'm sorry.
Environmental damage agreement, yeah. You mentioned at the beginning that the Dutch guidelines start off with the broad UN-based concept of sustainability, but then in this particular area of consumer benefit analysis, they focus on environmental damage agreements, which personally I think it's a terrible name because it suggests that the agreement is supposed to cause environmental damage, whereas it's exactly the opposite. It's supposed to mitigate environmental damages. But still, the benefits are related to the environment, indeed. Whereas the UK guidelines, you mentioned earlier, focus on, for the more flexible approach, they focus on climate change agreements. And those are defined as agreements which are referable to or support or promote the achievement of guidance or of obligations in international instruments which are binding in the UK to achieve climate change objectives, which again is interesting because there's a whole other debate, which we haven't really touched on, about the role of or the appropriateness of cooperation to achieve objectives which are legally required anyway, because there is a theory that that's the role of law enforcement, and companies should not be cooperating to allegedly enforce the law. And to throw yet another set of guidelines into the mix, the EU recently published a set of guidelines on sustainability agreements in the food and agri sector specifically. And those guidelines apply a even more flexible standard, but only to agreements to achieve sustainability or environmental objectives that go beyond the legally required. So there's a lot of variation. And as you mentioned earlier, Matthew, it creates a bit of a minefield for advisors.
Jay, you talked about the importance of thinking about different, who's affected. One dimension of that would be, geography or location, but another could be over time. And so I'm curious if the guidance, the latest guidance, is giving us any better sense of how authorities are going to think about those benefits and their relevant discount rate from an economic point of view. Essentially, the nearness or farness of the benefits in time.
Yeah, that is another area of difference, and I'm afraid all of the guidelines are a little bit vague on that. The European Commission has taken a rather restrictive view and suggested that because, among other things, because of the need to document and try to quantify benefits, that near-term benefits are going to be taken into account. The Dutch guidelines take a little bit of a different or opposite approach, at least in theory, because they say actually the greatest benefits, in particular in relation to climate change, may only be felt over a very long period of time, and that's actually a point in their favor rather than something which should lead to them being discounted. And then the UK guidelines, again, are somewhere in the middle. They say with respect to climate change agreements in particular, the benefits may only be achievable over a period of years, and we'll have to look at a case-by-case basis on what kind of discounting may be appropriate to deal with that.
Also looking at the UK draft guidelines, Jay, and distinguishing them from the Dutch draft guidelines, the Dutch guidelines seem to accept, in relation to environmental damage agreements, that the benefit could be from anyone to anyone anywhere, whereas the UK draft guidelines seem specifically to refer to UK individuals or to the UK population. So that seems to be a narrower approach on that issue in the UK.
Yes, and I don't know why, to be honest with you, because as we mentioned earlier, the CMA is responding to an unfavorable, at least depending on your point of view, case relating to the relevance of out-of-market benefits, and they've limited the eligibility of out-of-market benefits for this kind of analysis to climate change agreements. But even in the case of climate change agreements, as you say, they limit it to UK consumers, and that seems unnecessarily restrictive to me. And I suspect it will be one of the areas that they get comments about and will need to address in their final guidelines.
I think this is one of the criticisms that the Dutch regulator, or at least the head of the authority, has made of the European Commission guidelines, that they seem only to apply, for example, if you have an EU-wide agreement, they would only take a benefit into account for, in relation to climate change agreements, you'd only look at benefits to EU citizens, and obviously that's only a small proportion of the worldwide population, and the UK population is an even smaller part of the worldwide population, so you can take into account a small portion of the overall benefits, which would presumably limit the usefulness of some of those agreements.
No, that's true. And especially for purposes of listeners in the US, maybe it's worth clarifying some of the legal background here. In the EU, national authorities like the Dutch authority have the power, in parallel with the Commission, to apply EU law. So although the Dutch have their own competition law, the guidance in the Netherlands is an interpretation also of Article 1011 of the European Treaty, just as the European Commission guidelines are. And the European Commission guidelines are just that, they're guidelines. And at the end of the day, when there's a difference of opinion, it's up to, if there's a case in controversy, it's up to the European courts to decide who's right. And I think the Dutch authority, as you say, Matthew, has been critical of the Commission approach. They think the Commission is being too narrow. And at the end of the day, that difference may make its way up to the European courts.
Quite likely that we'll have some of those cases in due course, I imagine, as you say, Jay. Well, let's finish off the substantive discussion here. Again, Aaron asked you about this and you alluded to this earlier, but I think it's useful to come back to it. A comparison between the EU-UK situation and what is going on in the US. I think it'd be useful just if we could finish off with your comments on the differences and what that means as well for practitioners and companies, given that certainly in relation to climate change or biodiversity type agreements within environmental sustainability agreements, a lot of this is by definition worldwide.
Well, that's right. And I can start off, but I've been in Brussels for the last 35 years, and I'd like to hear Aaron's views on this as well, because he's much closer to the action. But the enforcement framework is different in various ways in the U.S. potentially because of the more open nature of the rule of reason analysis. You don't have the same level of detail in the guidelines, the types of guidelines that we see in the EU. And my impression, with all due respect, is that the U.S. agencies are less advanced in their thinking on these issues and maybe not so interested in them. There was a debate on the floor of the U.S. Senate, of all places, late last year about whether or not there is a quote-unquote environmental exemption in the U.S. antitrust laws, which, again, with all due respect, kind of missed the point. I mean, of course, there's no environmental exemption. The question is, what kind of environmental benefits do you take into account, and how do you weigh them against competitive harms that may be more traditional, more price related? And that being said, a lot of the enforcement activity in the U.S. takes the form of private litigation to a much greater extent than in Europe. And that, of course, is very diffuse. There are a lot of judges who could be called upon to apply the rule of reason to a given agreement, but it's going to be in a less coordinated way than we see in the guidelines that are being produced here in Europe. Aaron, does that sound right? Are you seeing any more activity than me sitting here in Brussels in the U.S.?
No, I think that's correct. I think that the analysis in the U.S. certainly hasn't caught up in one sense to the priorities you're describing, and yet at the same time, I'm not sure it's from a deficit of effort so much as a set of different definitions and maybe some competing priorities right now in the U.S. that lead the analysis in one direction as opposed to another. So we'll have to see whether ultimately authorities can build into their sense of what analysis is appropriate the kinds of priorities that are guiding folks in the EU and UK right now.
Yeah. One comment that Martijn Snoep from the Dutch authority made that I found really interesting was that when he first started working on the Dutch guidance, he was told by all the antitrust economists that he knew that it was difficult, or if not impossible, to quantify or even identify environmental benefits. And somebody put him in touch with some environmental economists who've been preparing the local equivalent of environmental impact statements, who said, "Oh, that's not impossible at all. We do that all the time." And indeed, in the U.S., environmental impact assessments have been developed since the 1970s under NEPA. So I think maybe it's an issue of the antitrust community getting a little bit outside of its box and looking to new sources of information.
As you say, maybe you need to look outside the box and remember there are other areas of law and economics. And as you say there, just to finish, Jay, both the Dutch guidelines and the UK guidelines specifically refer to methodologies for quantifying environmental benefits. So they have picked up and expressly refer to those issues. Well, that's been a great discussion. Thank you very much. At this stage, we like to turn to our more personal part of the podcast. We ask all our guests this question, but Jay, could you please tell us something interesting or unusual about yourself, which we would not know if we only knew you from a professional point of view?
Well, Matthew, you warned me about that question, and I'm afraid the answer may convince you that actually there's nothing interesting about me. But an example that I can give you is that I am a very early adopter of the podcast medium, having been listening to podcasts which are now so popular for 10 years or so, and I'm up to around 75 podcasts that I subscribe to. As I say, that might convince you that I'm the opposite of interesting.
Well, that's a lot of podcasts to subscribe to. You must have, well, I don't imagine you have much free time, but maybe you listen to them on, for kind of 4 times speed, so you can, get through them very, very quickly.
Well, I no longer listen to all the episodes, I have to admit.
Except for Our Curious Amalgam, of course, we hope.
I subscribe to that. That's one of them.
Excellent.
And now we have the Curious Hat.
And now it's time for the Curious Hat.
So Jay, as I think you know, we ask you here to choose a number between 1 and 12. And then there are questions against those numbers, and so we read out the question.
Okay, well, we only have a few minutes left, so I'll go with 3.
All right, number 3. How would you spend the perfect weekend?
Well, that's a good question. I would have to say in the winter, skiing in the Italian Dolomites. And any other time of year, probably touring, alternating museums, hiking, and eating. Preferably in the south of France or somewhere in Italy.
Well, that sounds great. I know you can. I think you can ski in the Belgian Ardennes, but at least at one place. But skiing in the Dolomites is no doubt better.
I wouldn't recommend the Ardennes. I'll probably get shot for that.
Probably. So, Thank you very much, Jay. Thank you, Aaron, for co-hosting with me today. And thank you, everyone, for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.